Patricia Visagie is standing by to give us a wrap of today's court proceedings. Patricia, very good afternoon to you and welcome to PM News. Now, another grueling day on the testimony stand today, and we saw a couple of adjournments today. Please take us through what happened in court today.
Well, good afternoon, Alicia, and to our viewers out there. It has certainly been another difficult and emotional day for the Paralympian on the stand, obviously, under cross-examination by State Prosecutor Advocate Gerrie Nel, who once again grilled him over what he calls the inconsistencies in his statement in comparison with that which he made during his bail application last year, shortly after shooting and killing Reeva Steenkamp. We saw him coming under immense scrutiny over when the advocate asked him whether he checked whether Reeva Steenkamp had left through his bedroom door shortly after he had fired those 4 shots through his bathroom door. He was unable to give a clear answer, and the advocate once again put emphasis on the fact that an argument must have ensued between the couple that forced Reeva Steenkamp to lock herself in the bathroom door, and that urged the Paralympian to react out of rage and shoot and kill her through the bathroom door. But to take us through today's court proceedings, I am joined by Advocate Patricia Pistorius, and he is a criminal law expert. Welcome to the PM News. Once again, we saw the Paralympian coming under immense scrutiny for his inconsistencies.
Yes, I believe the public must understand that the perceived inconsistencies will be evaluated by the trial judge at the end of the day, having regard to all the evidence. But you're quite correct, there is a number of inconsistencies which is worrisome. That creates difficulty for Mr. Pistorius.
And of course, the Blade Runner has repeatedly blamed his defense team for not including some elements in his testimony last year in comparison with what he is testifying about now in court.
Yes, I would believe that is a very unwise thing to do for any accused or witness for that matter, to blame his very competent legal team for not disclosing particular aspects of his defense, and particularly to admit to ask certain questions in cross-examination. It's one of those things that the witness simply do not do, and that is to blame counsel, because then it obviously enhances the view of the prosecution that he is doing the blaming, shifting the blame and not assuming responsibility.
There seems to also be confusion, especially on social media, on whether an accused is allowed to speak to his or her defense during cross-examination. What does the law entail in this matter?
Well, procedurally and ethically, once a witness is under cross-examination, he is not allowed to communicate whatsoever with his legal defense team. I see that Mr. Pistorius has indeed the record of the proceedings available to him, which I can understand, and that is totally admissible for him to read his own evidence and to prepare and study the evidence that he has given. But to seek legal counsel whilst under cross-examination is simply not permissible and will not happen.
Oscar Pistorius has also repeatedly denied killing Reeva Steenkamp, but yet also denying killing the so-called intruder that he believed was behind that bathroom door. And you told us earlier, it seems like he is changing his evidence. And why is that, and what does that mean for him?
Well, it's difficult for me to express a view whether he's indeed changing his evidence. What is worrisome, although, to me, is that it appears to me that he doesn't comprehend 100% his defense, whether he's relying on putative private defense or whether he indeed claims that it was an accident. It's totally different legal test then applicable, and it is troublesome for Mr. Pistorius, I would believe, at the end of the day, if he's not pronouncing and communicating his defense properly, that the court may reject his version in totality.
Now, talking about a putative private defense, can you just explain that legal term for us?
It's when a person kills somebody believing subjectively that his life is in danger, when objectively speaking, as in the case, there is no fear whatsoever. So he made an honest mistake, subjectively thinking that there's a threat on his life, whilst we all know that that was simply not true and not the case.
But the state also have another legal term that they're putting forward, and that is the dolus eventualis. Can you explain to us what that means?
Yes, in a murder case, one of the elements of the crime is a criminal intent in two forms. That is dolus directus, when one has a direct intent to kill, and dolus eventualis, which is an indirect form of intent. And simply it means when a person foresees a particular result, he reconciles with that particular result without distancing from that, then he's reckless. We also refer to it as reckless intent. In this instance, he foresees that somebody was behind the door, and without thinking of the consequences, he simply shot. And that is dolus eventualis in law.
But the defense is arguing the reasonable man argument. With all the inconsistencies in the Paralympian statement, could he still put that forward?
Yes, that is the very difficult choice that Mr. Pistorius faced when he elected not to plead to a charge of culpable homicide from the outset, because it would become progressively difficult to argue on his version that he did not act reasonably, and hence his actions fall short of the reasonable man test, which is clearly the test applicable when you assume responsibility on the lesser charge of culpable homicide. My fear is that Mr. Pistorius, by denying guilt and pleading innocence, is going to have an upward struggle to convince a court that his actions was in the alternative, not reasonable, hence that he's guilty of culpable homicide.
Now, let's talk about Advocate Gerrie Nel here. We saw him also being taken to task by Judge Thokozile Masipa about twice today. You also said that maybe there is a outcry out there about his style of cross-examination. And why is that?
Look, when a person is cross-examined, it means simply that the interrogator should not be cross at the witness. That implying that any witness must be treated with respect, with dignity. And I have particular, and that is only my view, difficulty with him confronting Mr. Pistorius, telling him that he's a liar, that he's lying to the court. That is at the end of the day for the court to decide who is giving the correct version or not. And not for Mr. Nel to simply and blatantly call Mr. Pistorius a liar. I would be offended if my client was to be called a liar. Even although Mr. Nel probably is entitled to do so, I think he's going a bit far by calling him an outright liar.
And of course, you are also innocent until proven guilty.
Exactly so.
Right. And that was Advocate Pistorius giving us an in-depth analysis of today's court proceedings here at the Oscar Pistorius murder trial at the North Gauteng High Court. Of course, tomorrow the Paralympian will continue under cross-examination by State Prosecutor Advocate Gerrie Nel, and that means his agony is far from over, as the advocate has already indicated that he will be testing him on several elements that has already come out in his testimony that he just blamed as, or labeled rather, as unbelievable. We will be back tomorrow again.
Thank you very much. That was SABC reporter Patricia Visagie coming to us live outside the North Gauteng High Court. The court resumes tomorrow.